My name is Adrian Resendez. I have my own law firm based out of Austin, Texas, the Resendez Law Firm, and we work in the areas of intellectual property, general business law, contracts, disputes, formation, and also immigration. And I am going to be explaining a little bit and talking about copyright law, which is an area of intellectual property law. So I'm going to talk a little bit about copyright law, and this does not constitute legal advice, but will be general information for copyright law in the United States. So copyright law in the United States is based off of really two sources of law, and those sources of law are the Constitution and some of the statutes that have been created over time. So what can be copyrighted? Copyright is an original work of authorship, cannot be copied from another because they likely have the copyright, or it has to be an original work of authorship. So some examples are literary works, musical works, dramatic works, pantomimes even, movies, etc. So the real requirement, a lot of people ask, does a copyright have to be registered? The real requirement is for it to be what's called fixed in any tangible medium of expression. What fixed means is really, if I take a piece of paper and a pen and I draw something out and write it out, I have a copyright in that if there's at least some creativity to it, and again, it's unique. It's not a copy of, what somebody's already had. So there's a lot of questions and there's whole areas of study into what fixed actually means. A lot of art, modern art, they use gardens, and a garden changes by the seasons. Does that mean it's fixed? All very good questions to consider when thinking about copyright. So who is an author? So the law states that an author, and this has been fought in case law and everything, because sometimes there's contractors, sometimes there's works for hire, but an author is the person to whom the work owes its origin and who superintended the whole work, the mastermind essentially. There's a lot of remix artists out there and everything. So who owns the copyright? Well, the copyright could be owned by several entities depending on how many different sounds they use, songs they used, and all that. So again, going back to how do you get a copyright? You fix it. So in that case, you'd record it to a CD, an audio file, whatever. But that only allows you certain amounts of protection. What you want to do is, if you really see yourself making some money off of it, or it's a great idea, something you want to protect, you can file the copyright with the U.S. Copyright Office. It's actually pretty cheap. It depends on what the type of work is. And it's filed with the Library of Congress. And that copyrighted work is now registered on file, and it puts people on notice that there is a copyright that is registered. Now, that actually works out mostly in a lawsuit environment or a demand letter environment, meaning you have more leverage. You have more to get the person to stop, to cease and desist using your copyrighted work, and there's more damages that you're given by law for registering that copyright. So again, you don't have to register, but it's great. It's a great thing to do. So what happens when you have more than one person working on a copyright? Well, there's things called joint works, there's works made for hire, and even if you have an agreement, all of this copyright information, who owns it, everything can be contracted for. So you can lay out in a contract, you're making me, a website and with a logo and all that. So who owns the intellectual property rights? Who owns the copyright? All can be set out before the project's even done. And there's things about derivative works, meaning Somebody has, like Andy Warhol, there were original paintings, so he made derivative works. He changed up, Marilyn Monroe's picture. He put his own artistic expression. Was that enough to get him a copyright? More than likely, but again, it didn't get to court, so who, knows? All of it is an argument. So a couple final questions I usually get is, how long does copyright last? Well, for most works, it's the life of the author plus 70 years, meaning whoever they pass the rights on to can benefit economically or license it or whatever for, probably a period of their life too, 70 years. Some other works, and it depends on the dates of the work, 95 years from publication or 120 years from creation. Most of this law is actually based on Disney and Mickey Mouse. Every time any of Disney's copyrighted works is about to expire, they push for an extension, and due to their lobbying and their power and their influence, they usually get that determined. So finally, we'll end with fair use, because a lot of people like to throw around the term fair use. So fair use is actually a defense to infringement, meaning if you've infringed on somebody's copyright or benefited from their work somehow, you can use fair use as a defense. Now, fair use again is abuse. So what are some examples of actual fair use? So criticism is one. Commenting on somebody's quote, news reporting, teaching, scholarship related things, anything related to education really, and research. But the list really doesn't mean that all of that is protected. It's a case-by-case basis, and case law has shown us there's many factors that they use, 4 factors indeed: the purpose and character of the defendant's work, the nature of the copyrighted work, the amount and substantiality of the portion used, and the effect of the defendant's use on the market for defendant's work. So again, paintings, the painting market, the art world, music, the music world. So is what I'm doing fair use? I get this all the time. It depends. That's lawyer's favorite response, but that's what it boils down to. Thank you for tuning in, and I hope that it was informative. Again, I'm Adrian Resendez, the Resendez Law Firm. I'd like to thank Law Booth for having me on for this blog, and stay tuned for some more topics, likely immigration, which I also handle. So thank you.